Question 1. Operational review demonstrates that a Colorado real estate brokerage email server may have been targeted by a phishing attempt, potentially exposing client names, addresses, and contact information. The broker must decide how to proceed. Option A. Immediately notify the affected clients about the potential data exposure, explain the nature of the threat, and outline the steps the brokerage is taking to investigate and secure its systems. Option B. Inform clients that the brokerage IT systems are undergoing a general review without disclosing the specific nature of the potential security incident. Option C. Forward the suspicious email to the client and ask them to determine if their information has been compromised. Option D. Delete the suspicious email and assume it was a failed attempt, taking no further action to avoid alarming clients. Correct answer is A. Immediately notify the affected clients about the potential data exposure, explain the nature of the threat, and outline the steps the brokerage is taking to investigate and secure its systems. Explanation. This scenario presents a professional challenge because it requires a Colorado real estate broker to balance the immediate need for efficient client communication with the paramount obligation to protect sensitive client data. The broker must navigate potential data breaches and comply with Colorado's specific data privacy regulations, which, while not as prescriptive as some federal laws, still impose a duty of care. The broker's judgment is critical in selecting a method that is both practical and legally sound. The best approach involves immediately informing the client about the potential data exposure and outlining the steps being taken to mitigate the risk. This includes clearly communicating the nature of the breach, the types of data potentially affected, and the actions the brokerage is implementing to secure systems and prevent future incidents. This proactive and transparent communication aligns with ethical duties of honesty and diligence owed to clients. Furthermore, it demonstrates a commitment to data protection principles, which are increasingly expected and implicitly required under Colorado law to safeguard consumer information. This approach prioritizes client trust and legal compliance by addressing the issue head-on with the affected party. An incorrect approach would be to ignore the suspicious email and hope it was a false alarm. This failure to investigate and act on a potential security threat is a direct violation of the duty of care owed to clients. It exposes the brokerage and its clients to significant risks of identity theft and financial fraud, and would likely be viewed as negligence under Colorado law, potentially leading to disciplinary action by the Colorado Real Estate Commission. Another incorrect approach would be to delete the suspicious email without informing the client or taking any internal security measures. This demonstrates a lack of diligence and a failure to address a potential security vulnerability. It leaves the client uninformed about a risk to their personal data and fails to implement necessary safeguards, which could be interpreted as a breach of professional responsibility and a disregard for data protection obligations. A further incorrect approach would be to inform the client only that systems are being reviewed, without providing specific details about the potential exposure or the steps being taken. This vague communication fails to adequately inform the client of the risks they may face and does not demonstrate a concrete plan to address the issue, thus falling short of the transparency and proactive measures required for responsible data protection and client service. Professionals should adopt a decision-making framework that prioritizes client data security and transparency. This involves establishing clear internal protocols for handling suspected data breaches, including immediate investigation, assessment of risk, and prompt, clear communication with affected parties. When faced with uncertainty, erring on the side of caution and prioritizing client protection is always the most ethically and legally sound path. Question 2. Risk assessment procedures indicate that a Colorado mortgage broker is assisting a first-time homebuyer who is eager to secure a loan with the lowest possible initial monthly payment. The borrower is presented with an adjustable rate mortgage, ARM, option that features a significantly lower introductory interest rate compared to fixed-rate options, but includes a substantial balloon payment at the end of the loan term and potential for significant interest rate increases after the initial period. The borrower expresses excitement about the initial affordability, but seems less engaged when the broker begins to explain the complexities of the ARM's rate adjustments and the implications of the balloon payment. What is the most responsible course of action for the Colorado mortgage broker? Option A. Downplay the risks associated with the adjustable rate mortgage and the balloon payment, emphasizing only the initial low interest rate to secure the borrower's immediate approval. Option B. Focus on the borrower's stated desire for the lowest initial payment and proceed with the ARM application, assuming the borrower will ask questions if they have concerns about the rate adjustments or balloon payment. Option C. Thoroughly explain all terms of the adjustable rate mortgage, including the potential for interest rate increases, the mechanics of the balloon payment, and the associated risks, ensuring the borrower understands these aspects before proceeding with the application. Option D. Advise the borrower that they can easily refinance before the balloon payment is due, without fully disclosing the costs and uncertainties of future refinancing, to alleviate their immediate concerns. The correct answer is C. Thoroughly explain all terms of the adjustable rate mortgage, including the potential for interest rate increases, the mechanics of the balloon payment, and the associated risks, ensuring the borrower understands these aspects before proceeding with the application. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a mortgage broker in Colorado to balance the borrower's immediate financial needs with the long-term implications of loan terms, all while adhering to strict disclosure requirements under Colorado law. The broker must avoid actions that could be construed as predatory or misleading, ensuring the borrower fully understands the commitment they are making. Careful judgment is required to navigate the borrower's emotional state and potential lack of financial literacy. Correct approach analysis. The best professional practice involves thoroughly explaining all loan terms, fees, and potential risks to the borrower in clear, understandable language, and documenting this explanation. This approach directly aligns with Colorado's consumer protection laws regarding mortgage lending, which mandate transparency and full disclosure to borrowers. By ensuring the borrower comprehends the implications of the adjustable rate mortgage, including potential payment increases and the risks associated with a balloon payment, the broker fulfills their ethical and legal obligation to act in the borrower's best interest and prevent future financial distress. This proactive disclosure and verification of understanding is paramount. Incorrect approaches analysis. One incorrect approach involves downplaying the risks of the adjustable rate mortgage and the balloon payment, focusing solely on the initial lower interest rate. This is ethically problematic as it misrepresents the true cost and risk profile of the loan, potentially leading the borrower into a financial situation they cannot manage. It violates the principle of full disclosure mandated by Colorado regulations, which require all material terms and risks to be clearly communicated. Another incorrect approach is to proceed with the loan application without confirming the borrower's understanding of the adjustable rate features and the balloon payment, assuming the borrower will ask questions if they have concerns. This passive approach fails to meet the broker's affirmative duty to ensure comprehension. Colorado law expects brokers to be proactive in educating borrowers about complex loan products, not to rely on the borrower to initiate all clarification. A third incorrect approach is to suggest that the borrower can simply refinance before the balloon payment is due, without providing concrete evidence or a clear plan for how this would be achieved, and without disclosing the associated costs and risks of refinancing. This creates a false sense of security and can be considered a misleading practice, as future refinancing is not guaranteed and depends on market conditions and the borrower's financial standing at that future time. This also circumvents the requirement for full disclosure of the current loan's terms. Professional reasoning. Professionals should employ a decision-making framework that prioritizes borrower education and transparency. This involves 1. Understanding the borrower's financial situation and goals. 2. Clearly identifying and explaining all loan products and their associated risks and benefits. 3. Using plain language and providing written documentation for all disclosures. 4. Verifying borrower comprehension through active questioning and confirmation. 5. Documenting all interactions and disclosures. 6. Adhering strictly to all Colorado Division of Real Estate regulations and ethical guidelines for mortgage brokers. Question 3. Risk assessment procedures indicate that a prospective buyer in Denver, Colorado, has expressed a strong preference for neighborhoods with a specific demographic composition, stating, "I'm only interested in areas where families with young children are prevalent." As a licensed Colorado real estate broker, how should you ethically and legally respond to this buyer's stated preference? Option A. Agree to focus your search exclusively on neighborhoods that you know have a high concentration of families with young children, as this is the buyer's explicit request. Option B. Suggests that certain neighborhoods might be a better fit for families with young children, subtly guiding them towards areas that align with their demographic preference. Option C. Advise the buyer that you cannot help them if they are unwilling to compromise on their demographic-based neighborhood preference, as it may lead to complications. Option D. Inform the buyer that while you understand their preference, fair housing laws prohibit steering clients to or away from neighborhoods based on familial status or other protected characteristics, and you will assist them in finding suitable properties that meet their needs without regard to such factors. The correct answer is D. Inform the buyer that while you understand their preference, fair housing laws prohibit steering clients to or away from neighborhoods based on familial status or other protected characteristics, and you will assist them in finding suitable properties that meet their needs without regard to such factors. Explanation: this scenario is professionally challenging because it requires a real estate broker to navigate a situation where a potential client's request, while seemingly innocuous, could lead to discriminatory practices prohibited by federal and Colorado fair housing laws. The broker must balance the client's stated preferences with their legal and ethical obligations to provide housing opportunities without regard to protected characteristics. Careful judgment is required to avoid steering or facilitating discrimination. The correct approach involves politely but firmly educating the client about fair housing laws and explaining that the brokerage cannot fulfill requests that discriminate based on protected classes. This approach directly upholds the principles of the Fair Housing Act and Colorado's Anti-Discrimination Act. By explaining that the brokerage operates within legal boundaries and cannot act on discriminatory preferences, the broker is fulfilling their ethical duty and legal obligation to prevent discrimination. This demonstrates a commitment to fair housing and protects both the client and the brokerage from potential legal repercussions. An incorrect approach would be to agree to the client's request without question. This directly violates fair housing laws by facilitating discrimination based on a protected characteristic. Ethically, it is unacceptable for a real estate professional to participate in or enable discriminatory practices. Another incorrect approach would be to attempt to subtly steer the client towards or away from certain neighborhoods based on the client's stated preference, even if not explicitly agreeing to the discriminatory request. This is a form of steering, which is illegal under fair housing laws, as it limits a person's housing choices based on protected characteristics. A third incorrect approach would be to dismiss the client's request outright without any explanation or attempt to educate them. While not directly engaging in discrimination, this fails to uphold the professional responsibility to inform clients about fair housing laws and the brokerage's commitment to non-discrimination. It misses an opportunity to guide the client towards lawful and ethical housing practices. Professionals should employ a decision-making framework that prioritizes legal compliance and ethical conduct. When faced with a client request that may violate fair housing laws, the framework should involve 1. Identifying the potential fair housing issue. 2. Recalling relevant federal and state fair housing laws, Fair Housing Act, Colorado Anti-Discrimination Act. 3. Politely but clearly communicating legal limitations and ethical obligations to the client. 4. Offering to assist the client in finding housing that meets their needs without violating fair housing principles. 5. Documenting the interaction. Question 4. Strategic planning requires a Colorado real estate broker to accurately categorize properties for effective client representation and compliance. A broker is presented with a property that includes a substantial dwelling, a large, well-maintained barn, and 80 acres of land actively used for raising cattle and growing hay. The owner resides in the dwelling. What is the most appropriate classification for this property under Colorado real estate law for brokerage purposes? Option A, mixed-use property. Option B, commercial property. Option C, agricultural property. Option D, residential property. The correct answer is C, agricultural property. Explanation: this scenario is professionally challenging because a real estate broker must accurately identify the primary classification of a property to ensure compliance with Colorado's licensing laws and regulations, particularly concerning advertising and client representation. Misclassifying a property can lead to violations, misinformed clients, and potential legal repercussions. Careful judgment is required to distinguish between property types based on their predominant use and characteristics, as defined by Colorado real estate law. The best professional approach involves a thorough assessment of the property's primary function and characteristics to determine its classification under Colorado real estate law. This means evaluating whether the property's predominant use is for dwelling purposes, business operations, manufacturing, or cultivation. For instance, a property with a large barn and extensive acreage primarily used for livestock and crop production would be classified as agricultural, even if it includes a small residential dwelling. This aligns with Colorado's regulatory framework, which recognizes these distinct categories for licensing and transaction purposes. An incorrect approach would be to classify the property based solely on the presence of a residential structure, ignoring other significant features. For example, labeling a property with a farmhouse, several outbuildings, and 100 acres of actively farmed land as purely residential would be a misclassification. This fails to acknowledge the agricultural nature that defines the property's primary economic and functional purpose under Colorado law, potentially leading to improper marketing or advice. Another incorrect approach is to classify the property based on its potential for future development, rather than its current primary use. A property currently operating as a commercial warehouse, even if zoned for future residential conversion, should be treated as commercial for current brokerage activities. Focusing on speculative future use rather than established present function violates the principle of accurate representation required by Colorado's real estate regulations. Finally, classifying the property based on the owner's personal preference or a secondary use without considering the predominant characteristic is also professionally unsound. If a property is predominantly industrial, but the owner wishes to market it as a unique residential loft space, the broker must still adhere to the property's actual classification for regulatory compliance. Professionals should employ a decision-making framework that prioritizes accurate property classification based on its predominant current use and characteristics, as defined by Colorado statutes and regulations. This involves consulting relevant zoning information, understanding the property's historical and current operations, and considering the primary purpose for which it is being marketed or transacted. When in doubt, consulting with legal counsel or relevant local authorities is advisable to ensure strict adherence to Colorado's real estate laws. Question 5. Risk assessment procedures indicate that the Colorado real estate market in a specific suburban county is experiencing a significant increase in housing inventory and a slowdown in buyer demand due to rising interest rates. A seller client, who is eager to sell quickly, has expressed a desire to list their property at a price significantly above the current market value, based on recent sales from 6 months ago. As a licensed Colorado real estate broker, which of the following approaches best addresses this situation? Option A. Guarantee the seller that the property will sell within their desired price range within 30 days, citing the seller's urgency as a reason to expedite the process, and proceed with listing at their requested price. Option B. Advise the seller that their desired price is unrealistic and refuse to list the property unless they agree to a price that is significantly lower, without providing detailed market data to support the recommendation. Option C. Agree to list the property at the seller's desired price, assuring them that the market will eventually adjust to their price point, and focus marketing efforts on attracting buyers willing to pay a premium. Option D. Conduct a comprehensive comparative market analysis, CMA, that reflects current market conditions, present this data to the seller, and advise on a pricing strategy that balances their desire for a quick sale with realistic market expectations. The correct answer is D. Conduct a comprehensive comparative market analysis, CMA, that reflects current market conditions, present this data to the seller, and advise on a pricing strategy that balances their desire for a quick sale with realistic market expectations. Explanation. This scenario is professionally challenging because it requires a Colorado real estate broker to balance the immediate financial interests of their client with the broader economic realities of the local market, while adhering to ethical duties and Colorado's specific real estate regulations. The broker must provide informed advice without making guarantees or misrepresenting market conditions. The best approach involves a thorough, data-driven analysis of current and projected market trends in Colorado, specifically within the relevant submarket. This includes examining factors like inventory levels, absorption rates, interest rate trends, employment figures, and local development projects. The broker should then present this objective analysis to the seller, outlining potential scenarios for pricing and sale timelines, and advising on a pricing strategy that reflects these economic realities. This aligns with Colorado Real Estate Commission regulations requiring brokers to exercise reasonable skill and care, and to present all offers and counteroffers in a timely manner, while also upholding the ethical duty to be honest and truthful. Providing a data-backed perspective allows the seller to make an informed decision based on realistic market expectations, rather than speculative optimism. An approach that focuses solely on the seller's desired price without considering current market data is professionally unacceptable. This fails to meet the duty of reasonable skill and care by not performing adequate market analysis, and could lead to the property being overpriced, remaining on the market, and ultimately selling for less than it might have if priced correctly initially. It also risks misrepresenting market conditions to the seller, violating the duty to be honest and truthful. Another unacceptable approach is to guarantee a specific sale price or timeline, regardless of market conditions. This is a direct violation of Colorado real estate law and ethical standards, as it constitutes misrepresentation and potentially fraudulent behavior. Brokers cannot predict the future with certainty, and making such guarantees is irresponsible and harmful to the client. Finally, an approach that dismisses the seller's concerns about market conditions and insists on a particular pricing strategy without open discussion is also professionally flawed. While data is crucial, effective client communication and understanding the seller's motivations are also vital. A broker must be able to explain their reasoning clearly and collaboratively work with the seller to arrive at a mutually agreeable strategy, even if it involves gently challenging the seller's initial price expectations with solid evidence. Professionals should employ a decision-making framework that prioritizes objective data analysis, transparent communication with the client, and adherence to all relevant Colorado real estate laws and ethical codes. This involves understanding the economic factors influencing the local market, presenting this information clearly, and guiding the client towards a realistic and informed decision that serves their best interests while maintaining professional integrity. Question 6. System analysis indicates a property manager in Colorado is handling the rental of a property where the owner has received a notice of intent to accelerate the loan due to missed payments, though formal foreclosure proceedings have not yet been initiated. A prospective tenant has submitted an application and is eager to sign a lease agreement. What is the most appropriate course of action for the property manager to ensure compliance with Colorado's regulatory framework and ethical obligations? Option A. Wait for the prospective tenant to specifically ask about the property's financial status or any potential issues before disclosing the owner's loan default. Option B. Provide the foreclosure disclosures only after the lease agreement has been signed and the tenant has paid their security deposit and first month's rent. Option C. Inform the tenant that since formal foreclosure has not begun, no disclosures related to the owner's financial situation are necessary at this time. Option D. Immediately provide the prospective tenant with all legally required disclosures, including specific information regarding the owner's loan default and the potential for foreclosure, before accepting any earnest money or signing the lease. The correct answer is D. Immediately provide the prospective tenant with all legally required disclosures, including specific information regarding the owner's loan default and the potential for foreclosure, before accepting any earnest money or signing the lease. Explanation. This scenario is professionally challenging because it requires a property manager to balance the fiduciary duty owed to the property owner with the legal and ethical obligations to potential tenants, all while navigating the specific disclosure requirements of Colorado law. The manager must avoid discriminatory practices and ensure all legally mandated information is provided promptly and accurately. Careful judgment is required to prevent potential legal liabilities for the owner and the brokerage. The best professional approach involves proactively providing the tenant with all legally required disclosures, including the Colorado Foreclosure Protection Act disclosures, as soon as they are reasonably available and before any lease is signed or earnest money is accepted. This approach aligns with the Colorado Real Estate Commission's emphasis on full and timely disclosure to prevent misrepresentation and ensure informed decision-making by all parties. By providing these disclosures upfront, the property manager demonstrates transparency, upholds their fiduciary duty to the owner by mitigating risks associated with undisclosed information, and adheres to the spirit and letter of Colorado's landlord-tenant and foreclosure laws. This proactive stance minimizes the likelihood of future disputes and legal challenges. An incorrect approach involves waiting for the tenant to inquire about the foreclosure status before providing any information. This failure to proactively disclose material information, especially concerning a potential foreclosure which significantly impacts a tenant's rights and occupancy, violates the principle of full disclosure and could be construed as a misrepresentation or omission under Colorado law. It also fails to meet the ethical standard of acting in the best interest of all parties by withholding crucial information that affects the tenant's decision to rent. Another incorrect approach is to only provide the foreclosure disclosures after the lease has been signed and the tenant has paid a deposit. This is a critical failure because it deprives the tenant of the opportunity to make an informed decision before committing financially. Colorado law aims to protect tenants from situations where their tenancy could be abruptly terminated due to circumstances unknown to them at the time of signing. This delay in disclosure creates a significant risk of legal action and ethical breach. Finally, an incorrect approach is to assume that since the property is not yet in foreclosure, no disclosures are immediately necessary. While formal foreclosure proceedings may not have commenced, the existence of a notice of intent to accelerate or other pre-foreclosure actions can still trigger disclosure obligations under Colorado law, especially if these actions materially affect the tenant's ability to occupy the property or their rights. The property manager has a duty to be aware of and disclose such material facts, even if they are not yet at the final stage of foreclosure. Professionals should adopt a decision-making framework that prioritizes transparency and compliance. This involves understanding all applicable Colorado statutes and regulations related to landlord-tenant relationships and property sales/foreclosures. When a situation presents potential material facts that could impact a tenant's occupancy or rights, the professional should err on the side of overdisclosure, providing information as early as possible in the leasing process, and always before any financial commitment is made by the tenant. Regular review of legal updates and consultation with legal counsel when in doubt are also crucial components of this framework. Question 7. System analysis indicates a Colorado licensed real estate broker is representing a seller in a transaction. The broker receives an offer to purchase the seller's property from a buyer who is a close relative of the broker. What is the most appropriate and legally compliant course of action for the broker to take? Option A. Wait until the offer is accepted by the seller before disclosing the familial relationship to the seller. Option B. Advise the seller to reject the offer, citing the potential for complications due to the broker's personal connection. Option C. Present the offer to the seller without mentioning the familial relationship, assuming the seller will not be negatively impacted. Option D. Immediately disclose the relationship to the seller in writing and allow the seller to decide how to proceed with the offer. The correct answer is D. Immediately disclose the relationship to the seller in writing and allow the seller to decide how to proceed with the offer. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a broker's fiduciary duty to their client and the potential for personal gain. Navigating this requires a deep understanding of Colorado real estate law concerning disclosure, agency, and conflicts of interest. The broker must prioritize the client's best interests while adhering to strict legal and ethical standards. Correct approach analysis. The best professional practice involves immediately disclosing the potential conflict of interest to the seller in writing. This approach is correct because Colorado Revised Statutes, C.R.S. Section 12-10-203 mandates that real estate brokers act honestly and truthfully, and disclose all material facts that could affect a client's decision. Furthermore, ethical standards require full transparency when a broker has a personal interest in a transaction, ensuring the client can make an informed decision without undue influence. This proactive disclosure upholds the broker's fiduciary duty and prevents potential legal ramifications. Incorrect approaches analysis. Presenting the offer without disclosing the personal interest is a significant ethical and legal failure. It violates the duty of honesty and full disclosure required by C.R.S. Section 12-10-203 and undermines the trust inherent in the broker-client relationship. This action could be construed as self-dealing and a breach of fiduciary duty, leading to disciplinary action by the Colorado Real Estate Commission and potential civil liability. Advising the seller to reject the offer due to the broker's personal interest, without full disclosure, and allowing the seller to make their own informed decision, is also professionally unacceptable. While seemingly protecting the seller, it usurps the seller's right to evaluate all offers and make their own judgment. This paternalistic approach bypasses the required transparency and can be seen as manipulating the transaction for the broker's perceived benefit, rather than acting solely in the client's best interest. Waiting until after the offer is accepted to disclose the personal interest is a critical failure. Disclosure must be made at the earliest opportunity, before any binding agreement is made, to allow the seller to fully consider its implications. Delaying disclosure deprives the seller of the ability to make a truly informed decision at the crucial stage of offer acceptance and is a violation of disclosure requirements. Professional reasoning. Professionals in this situation should employ a decision-making process that prioritizes transparency and client autonomy. The first step is to recognize the potential conflict of interest. Immediately following this recognition, the broker must consult the relevant Colorado statutes and ethical guidelines to understand their disclosure obligations. The paramount principle is to inform the client fully and in writing about the conflict, allowing the client to decide how to proceed. This ensures that the client's interests are protected and that the broker acts within legal and ethical boundaries. Question 8. The performance metrics show a recent listing in Denver, Colorado, has generated significant interest, but a potential buyer has inquired about a utility access point visible on the property. The listing broker is aware that this access point is part of an established easement for a neighboring property's drainage system. What is the most responsible and legally compliant course of action for the broker? Option A. Suggest to the seller that they attempt to block or obscure the utility access point to make it less noticeable to potential buyers. Option B. Inform the buyer that there is an access point on the property but refrain from providing further details, stating it is a matter for the buyer to investigate independently. Option C. Immediately inform the potential buyer about the existence and nature of the drainage easement, providing details on its scope and potential impact on the property's use, and advise the seller to consult with an attorney regarding the easement's implications. Option D. Advise the seller that the easement is likely a minor issue and not worth mentioning to buyers, as it might deter interest in the property. The correct answer is C. Immediately inform the potential buyer about the existence and nature of the drainage easement, providing details on its scope and potential impact on the property's use, and advise the seller to consult with an attorney regarding the easement's implications. Explanation. This scenario is professionally challenging because it requires a real estate broker in Colorado to navigate the complexities of property rights and ownership, specifically concerning easements, without misrepresenting the property's condition or encumbrances. A broker's duty is to disclose all material facts that could affect a buyer's decision, and failure to do so can lead to legal repercussions and ethical violations. The best approach involves a thorough investigation and clear disclosure of the easement's nature and implications. This means confirming the existence and scope of the easement, understanding how it impacts the property's use and value, and communicating this information transparently to potential buyers. This aligns with Colorado revised statutes concerning disclosure obligations and the general duty of care owed by real estate professionals to their clients and the public. Specifically, brokers are obligated to disclose no material defects and encumbrances that could affect the property's value or desirability. An incorrect approach would be to assume the easement is minor and not worth mentioning, or to downplay its significance without a full understanding. This demonstrates a failure to uphold the broker's fiduciary duty and violates Colorado's disclosure requirements, potentially misleading buyers about the property's true condition and their rights. Another incorrect approach is to advise the seller to ignore the easement or attempt to conceal it from potential buyers. This is unethical and illegal, as it constitutes active misrepresentation and fraud. Brokers are prohibited from participating in or facilitating fraudulent activities. Finally, an incorrect approach is to simply state that an easement exists without providing any details about its type, purpose, or impact. While technically disclosing its presence, this lacks the necessary specificity to inform a buyer adequately and fulfill the broker's duty of care. A buyer needs to understand the practical implications of the easement on their intended use of the property, Professionals should adopt a decision-making framework that prioritizes transparency, due diligence, and adherence to regulatory requirements. This involves proactively identifying potential issues, thoroughly researching them, and communicating findings clearly and comprehensively to all parties involved. When in doubt about the implications of a property right or ownership issue, seeking clarification from legal counsel or relevant authorities is a prudent step. Question 9. Analysis of real estate market cycles in Colorado requires a broker to consider various economic indicators. When advising a client on a potential investment property in Denver, which approach best demonstrates a broker's commitment to professional competence and client welfare under Colorado real estate law? Option A. Offering investment recommendations based on personal observations of neighborhood desirability and anecdotal success stories from other clients. Option B. Correlating current and projected market trends with the client's specific financial goals and risk tolerance, and educating them on how different market phases might impact their investment. Option C. Relying solely on the average appreciation rates of Denver properties over the past 2 decades to predict future returns. Option D. Focusing primarily on recent news headlines about the Denver housing market to gauge immediate buying opportunities. The correct answer is B. Correlating current and projected market trends with the client's specific financial goals and risk tolerance, and educating them on how different market phases might impact their investment. Explanation. Scenario analysis. This scenario presents a professional challenge for a Colorado real estate broker because it requires them to navigate the complexities of real estate market cycles and their impact on client advice, while adhering to Colorado's specific licensing laws and ethical obligations. Brokers have a fiduciary duty to their clients, which includes providing accurate and timely information. Misinterpreting or failing to account for market trends can lead to poor investment decisions for clients, potentially resulting in financial losses and damage to the broker's reputation and license. The challenge lies in balancing market analysis with the specific needs and risk tolerance of each individual client, all within the regulatory framework of Colorado. Correct approach analysis. The best professional approach involves a comprehensive assessment of current and projected real estate market conditions in Colorado, considering factors like interest rates, inventory levels, employment trends, and local economic development. This analysis should then be directly correlated with the client's specific financial goals, risk tolerance, and investment horizon. A broker employing this approach will educate the client on how different market phases, e.g., expansion, peak, contraction, trough, might affect their investment strategy, presenting both opportunities and risks. This aligns with Colorado Real Estate Commission regulations that mandate brokers act with honesty, integrity, and competence, and to disclose all material facts that could affect a client's decision. Ethically, this approach prioritizes the client's best interests by providing informed guidance tailored to their unique situation, rather than offering generic advice. Incorrect approaches analysis. One incorrect approach involves solely relying on historical market data without considering current economic indicators or future projections. This fails to acknowledge that past performance is not indicative of future results and can lead to outdated or irrelevant advice, potentially violating the duty of competence and diligence required by Colorado law. Another incorrect approach is to focus exclusively on short-term market fluctuations without understanding the broader real estate cycle. This can lead to impulsive client decisions based on temporary market shifts, which may not align with long-term investment objectives and could expose the client to undue risk, contravening the broker's obligation to act in the client's best interest. A third incorrect approach is to provide advice based on personal opinions or anecdotal evidence rather than objective market analysis. This lacks the professional rigor expected of a licensed broker and can be misleading, potentially violating Colorado's regulations against misrepresentation and requiring brokers to possess adequate knowledge of market conditions. Professional reasoning. Professionals should adopt a decision-making framework that begins with understanding the client's objectives and risk profile. This is followed by a thorough, data-driven analysis of the relevant market, considering both historical trends and current/projected conditions. The broker must then synthesize this information, translating complex market dynamics into understandable advice that directly addresses the client's situation. Transparency about potential risks and opportunities. along with a clear explanation of how market cycles might impact the client's investment, is paramount. This process ensures that advice is not only competent and compliant with Colorado regulations, but also ethically sound and client-centric. Question 10. The review process indicates a Colorado real estate broker is advising a client on purchasing a home. The client is considering two mortgage options for a $300,000 loan at a 6% annual interest rate, a 30-year fixed-rate mortgage, and a 15-year interest-only mortgage. The broker needs to accurately calculate and explain the total interest paid over the life of each loan to help the client make an informed decision. What is the total interest paid over the life of each mortgage, and which calculation method is most appropriate for a Colorado broker to use when advising a client? Option A. For the 30-year fixed-rate mortgage, the total interest paid is $383,705. 16. For the 15-year interest-only mortgage, the total interest paid is $270,000. The broker should calculate the total interest paid for both loan types to provide a comprehensive financial comparison. Option B. For the 30-year fixed-rate mortgage, the monthly payment is $1,798.65. For the 15-year interest-only mortgage, the monthly payment is $1,500.00. The broker should present these monthly payments as the primary basis for comparison. Option C. For the 30-year fixed-rate mortgage, the total interest paid is $383,705.16. For the 15-year interest-only mortgage, the total interest paid is $270,000. The broker should focus on the lower initial monthly payment of the interest-only loan to highlight potential short-term savings. Option D. For the 30-year fixed-rate mortgage, the total interest paid is $383,705.16. For the 15-year interest-only mortgage, the total interest paid is $135,000. The broker should only calculate the total interest for the fixed-rate mortgage, as it is a more common and straightforward option. The correct answer is A. For the 30-year fixed-rate mortgage, the total interest paid is $383,705.16. For the 15-year interest-only mortgage, the total interest paid is $270,000. The broker should calculate the total interest paid for both loan types to provide a comprehensive financial comparison. Explanation. Scenario analysis. This scenario presents a professional challenge for a Colorado real estate broker because it requires not only an understanding of different mortgage types, but also the ability to accurately calculate and explain the financial implications of each to a client. Misinterpreting or miscalculating these implications can lead to a client making a financially detrimental decision, potentially resulting in ethical breaches and regulatory violations under Colorado real estate law, which mandates that brokers act in the best interest of their clients and provide accurate information. The broker must demonstrate competence in financial calculations and clear communication. Correct approach analysis. The best professional practice involves accurately calculating the total interest paid over the life of the loan for both mortgage types and presenting this information clearly to the client. For the fixed-rate mortgage, the monthly principal and interest payment can be calculated using the standard loan payment formula. The total interest paid is then the total amount paid over the loan term minus the principal. For the interest-only mortgage, the monthly payment is simply the interest amount, and the principal is paid in a lump sum at the end. The total interest paid is the monthly interest payment multiplied by the number of years, assuming no principal is paid down during the term. This approach is correct because it directly addresses the client's need to understand the long-term financial commitment and cost associated with each loan option, enabling an informed decision. Colorado's real estate regulations emphasize transparency and fiduciary duty, requiring brokers to provide accurate and complete information to assist clients in making sound financial choices. Incorrect approaches analysis. One incorrect approach is to only calculate the initial monthly payment for both mortgage types and present those figures. This fails to provide the client with a complete picture of the total cost of borrowing over the life of the loan, particularly for the interest-only mortgage where principal repayment is deferred. This lack of comprehensive financial disclosure violates the broker's duty to act in the client's best interest and can be considered misleading under Colorado law. Another incorrect approach is to focus solely on the lower initial monthly payment of the interest-only mortgage, without adequately explaining the significant principal repayment due at the end of the term, and the fact that no equity is built through principal reduction during the interest-only period. This omission can lead the client to believe the interest-only option is always more affordable long-term, which is not the case, and can result in severe financial distress when the balloon payment is due. This constitutes a failure to provide material information, a breach of ethical conduct, and potentially a violation of Colorado's consumer protection laws related to real estate transactions. A further incorrect approach is to provide an estimated total interest paid for the fixed-rate mortgage, but to incorrectly calculate or omit the total interest for the interest-only mortgage, perhaps by only calculating the interest for the first year. This demonstrates a lack of diligence and competence in financial calculations, which is a fundamental requirement for a licensed real estate broker. Inaccurate financial advice can lead to significant client harm and expose the broker to liability and disciplinary action from the Colorado Division of Real Estate. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes client education and transparency. This involves 1. Thoroughly understanding the client's financial goals and risk tolerance. 2. Accurately calculating all relevant financial metrics for each option presented, including total interest paid, monthly payments, and any balloon payments. 3. Clearly and concisely explaining these calculations and their implications to the client, using plain language. 4. Documenting all advice and calculations provided to the client. This systematic approach ensures compliance with fiduciary duties and regulatory requirements, fostering trust and enabling clients to make informed decisions that align with their financial well-being. Question 11. Performance analysis shows that a property listed for sale in Denver, Colorado, has a history of industrial use in the immediate vicinity, raising concerns about potential soil and groundwater contamination. As the listing broker, what is the most responsible course of action to ensure compliance with Colorado real estate regulations and ethical practice? Option A. Advise the buyer to waive their right to an ESA to expedite the closing process, assuring them that environmental issues are unlikely to be significant. Option B. Advise the seller on their disclosure obligations regarding known environmental conditions and recommend the buyer conduct a Phase I environmental site assessment (ESSA) to identify potential risks. Option C. Encourage the seller to proceed with the sale without mentioning the historical industrial use, assuming any contamination is minor and will not affect the buyer. Option D. Inform the seller that the broker will discreetly investigate the environmental history and downplay any findings to facilitate a quicker sale. The correct answer is B. Advise the seller on their disclosure obligations regarding known environmental conditions and recommend the buyer conduct a Phase I environmental site assessment (ESSA) to identify potential risks. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker in Colorado to navigate potential environmental liabilities that could significantly impact a property's value and the transaction's success. Failure to properly address these issues can lead to legal repercussions, financial losses for clients, and damage to the broker's reputation. The broker must balance their fiduciary duty to the client with the legal and ethical obligations to disclose known material facts and comply with environmental regulations. Correct approach analysis. The best professional practice involves proactively identifying and disclosing potential environmental concerns to all parties involved in the transaction. This approach prioritizes transparency and due diligence. Specifically, the broker should advise the seller about their potential disclosure obligations under Colorado law regarding known environmental conditions and recommend obtaining a Phase I environmental site assessment (ESSA) to identify potential contamination. For the buyer, the broker should explain the importance of conducting their own due diligence, including the ESA, to understand the risks and potential remediation costs associated with the property. This aligns with the Colorado Real Estate Commission's brokerage duties and the general principles of ethical real estate practice, which mandate disclosure of known material defects and acting in the best interest of the client while adhering to all applicable laws. Incorrect approaches analysis. Recommending the seller ignore the potential contamination and proceed with the sale without disclosure is a significant ethical and legal failure. This violates the broker's duty to disclose known material facts and could expose both the seller and the broker to liability under Colorado law. Encouraging the buyer to waive their right to an ESA to expedite the closing, without fully explaining the potential risks and long-term implications, is also professionally unacceptable. This breaches the duty of care owed to the buyer and fails to uphold the principle of informed consent, suggesting that the broker will handle it by downplaying the significance of the environmental report without proper investigation or consultation with environmental professionals is negligent and potentially fraudulent. The broker is not qualified to make definitive environmental assessments and should not attempt to do so, as this bypasses necessary expert evaluation and regulatory compliance. Professional reasoning. Professionals should employ a decision-making framework that prioritizes transparency, due diligence, and adherence to legal and ethical standards. This involves 1. Identifying potential issues. Recognize when a property might have environmental concerns based on its history or surrounding area. 2. Educating clients. Clearly explain the potential risks and their legal/ethical obligations to both buyers and sellers. 3. Recommending expert consultation. Advise clients to engage qualified professionals, e.g., environmental consultants for assessments. 4. Facilitating disclosure. Ensure all known material facts, including potential environmental issues, are disclosed to all parties. 5. Documenting actions. Keep thorough records of all advice given and actions taken throughout the transaction. Question 12. The control framework reveals that a Colorado real estate broker is assisting a buyer client who wants to include a highly specific, non-standard clause in a residential purchase agreement to protect them from unforeseen environmental hazards discovered after closing. The broker believes the clause is poorly worded and may not be legally enforceable as written by the buyer. What is the most appropriate course of action for the Colorado broker? Option A. Draft the clause themselves, incorporating their understanding of the buyer's intent and standard contract language to ensure it is included in the agreement. Option B. Advise the buyer that the clause is non-standard and recommend they consult with a Colorado licensed real estate attorney to draft or review the clause to ensure its enforceability and alignment with their intent. Option C. Refuse to include the clause in the purchase agreement, stating that it is not a standard provision and the broker cannot accommodate such requests. Option D. Include the buyer's drafted clause verbatim in the purchase agreement and inform the seller's agent that the buyer's attorney will handle any legal review of the clause. The correct answer is B. Advise the buyer that the clause is non-standard and recommend they consult with a Colorado licensed real estate attorney to draft or review the clause to ensure its enforceability and alignment with their intent. Explanation. The control framework reveals that a Colorado real estate broker faces a professionally challenging situation when a buyer client insists on including a clause in a purchase agreement that is not standard and could potentially create legal ambiguity or disadvantage the seller. The challenge lies in balancing the broker's fiduciary duty to their client with the legal requirements of contract enforceability and ethical obligations to all parties involved in the transaction. Careful judgment is required to ensure the contract is legally sound, fair, and compliant with Colorado real estate law. The best professional approach involves advising the buyer on the potential implications of their requested clause, explaining its non-standard nature, and recommending consultation with a qualified Colorado real estate attorney to draft or review the clause. This approach is correct because it upholds the broker's duty to act in the client's best interest by informing them of potential risks and legal complexities, while also respecting the boundaries of legal advice. Colorado real estate law, specifically the Colorado Real Estate Commission's rules and regulations, emphasizes that brokers should not practice law. By recommending legal counsel, the broker ensures the contract is drafted by a licensed attorney, thereby protecting both the client and the broker from potential liability arising from an improperly drafted or unenforceable clause. This also aligns with the ethical obligation to conduct business with honesty and integrity. An incorrect approach involves the broker unilaterally drafting the non-standard clause themselves, believing they understand the client's intent and can adequately protect their interests. This is professionally unacceptable because it constitutes the unauthorized practice of law, a violation of Colorado statutes and commission rules. Brokers are not licensed attorneys and lack the legal expertise to draft complex contractual provisions that could have significant legal ramifications. This action exposes the broker to disciplinary action by the Colorado Real Estate Commission, potential civil liability if the clause leads to a dispute or financial loss for either party, and undermines the integrity of the transaction. Another incorrect approach is to simply refuse to include the clause without explanation or offering alternatives. While avoiding the unauthorized practice of law, this fails to adequately represent the buyer's interests. The broker has a duty to communicate and advise their client. Simply rejecting a client's request without providing context or suggesting a path forward, like legal counsel, can be seen as a dereliction of that duty and may lead to client dissatisfaction and potential claims of inadequate representation. A final incorrect approach is to include the clause without any discussion or advice to the buyer, assuming the seller's attorney will catch any issues. This is a passive and irresponsible stance. Brokers have an affirmative duty to ensure their clients understand the terms of the contracts they are entering into and to facilitate clear and legally sound agreements. Ignoring potential issues or shifting the entire burden of legal review to the other party's representative is a failure to uphold professional standards and could lead to disputes and legal complications that could have been avoided with proper diligence and advice. Professionals should employ a decision-making framework that prioritizes legal compliance, ethical conduct, and client advocacy. This involves 1. Understanding the client's request and its implications. 2. Assessing whether the request falls within the scope of a real estate broker's license and expertise. 3. If the request involves legal interpretation, drafting, or advice beyond the broker's purview, recommending consultation with a qualified legal professional. 4. Clearly communicating the rationale for such recommendations to the client. 5. Documenting all advice and recommendations provided. Question 13. Investigation of a residential lease agreement for a property in Denver, Colorado, reveals that the initial term is set for 1 year. The landlord has instructed the broker to ensure the lease allows for flexibility should they decide to sell the property before the year is up. Which of the following approaches best addresses the landlord's request while adhering to Colorado's landlord-tenant regulations and ethical brokerage practices? Option A. The lease clearly states a 1-year term and includes a specific clause allowing the landlord to terminate the lease with 90 days written notice and payment of 1 month's rent to the tenant, provided the termination is due to a bona fide sale of the property. Option B. The lease implies that after the initial 1-year term, the agreement will automatically convert to a month-to-month tenancy, allowing the landlord to terminate with minimal notice. Option C. The lease states that the 1-year term is subject to change based on the landlord's discretion, with no specific notice period or compensation required for early termination. Option D. The lease includes a general provision that the landlord may terminate the lease at any time for any reason, with only 30 days' notice. The correct answer is A. The lease clearly states a 1-year term and includes a specific clause allowing the landlord to terminate the lease with 90 days written notice and payment of 1 month's rent to the tenant, provided the termination is due to a bona fide sale of the property. Explanation. 1. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker in Colorado to navigate the nuances of lease agreements, specifically concerning the duration and termination clauses, while ensuring compliance with Colorado revised statutes, C.R.S., and ethical obligations to both landlord and tenant. Misinterpreting or misapplying these clauses can lead to legal disputes, financial losses, and damage to the broker's reputation. The broker must balance the landlord's desire for flexibility with the tenant's need for security and clarity. 2. Correct approach analysis. The best professional practice involves clearly defining the lease term and outlining specific conditions for early termination, ensuring these terms are mutually understood and agreed upon by both parties. This approach prioritizes transparency and adherence to Colorado law, which generally favors clear contractual terms. Specifically, a lease that states a fixed term, e.g., 1 year, and then details the conditions under which either party can terminate early, such as by providing a specified notice period, e.g., 60 days, and potentially a penalty, e.g., 1 month's rent, aligns with the principles of good faith and fair dealing expected of licensed real estate professionals in Colorado. This method ensures that both parties are aware of their rights and obligations throughout the lease period and under specific circumstances, minimizing ambiguity and potential disputes. 3. Incorrect approaches analysis. One incorrect approach is to assume a standard month-to-month tenancy automatically follows a fixed-term lease if no renewal is signed, without explicitly addressing this in the lease agreement. This fails to acknowledge that Colorado law may require specific notice periods for termination even in month-to-month situations, and it bypasses the agreed-upon terms of the initial lease, potentially violating C.R.S. Section 38-12-101 et sec. Regarding landlord obligations. Another incorrect approach is to include vague language about mutual agreement for early termination without defining what constitutes such an agreement or the process for achieving it. This leaves room for subjective interpretation and disputes, failing to provide the clarity required by contract law and potentially leading to a breach of contract claim. Third incorrect approach is to draft a lease that allows the landlord to terminate the lease at any time for any reason with minimal notice, without a corresponding right for the tenant. This is likely to be considered an unconscionable or unfair term under Colorado landlord-tenant law and could be challenged as a violation of tenant protections. 4. Professional reasoning. Professionals should always prioritize clear, unambiguous language in all contractual documents, especially lease agreements. They must be thoroughly familiar with Colorado revised statutes pertaining to landlord-tenant relationships and lease agreements. When drafting or reviewing lease terms, brokers should consider the potential for disputes and aim to mitigate them through precise wording. A decision-making framework should involve 1. Identifying the core intent of the parties. 2. Researching relevant Colorado statutes and case law. 3. Drafting clear and specific clauses that reflect the parties' intent and comply with the law. 4. Ensuring both parties fully understand and agree to all terms before signing. 5. Maintaining thorough documentation of all communications and agreements. Question 14. Comparative studies suggest that real estate brokers play a crucial role in guiding clients through financing decisions. In Colorado, a broker is assisting a client who is eager to purchase a property, but is concerned about their current credit score impacting their loan options. The client has found a property and a potential lender offering a loan with a significantly higher interest rate than market average, a substantial balloon payment due in 5 years, and a prepayment penalty. The broker's primary responsibility is to ensure the client makes an informed decision regarding this financing. Which of the following approaches best fulfills the broker's professional and regulatory obligations in Colorado? Option A. Recommend the lender to the client, emphasizing that this loan will allow them to purchase the property quickly, and assure them that the prepayment penalty can likely be negotiated later. Option B. Advise the client to accept the loan terms as presented by the lender, stating that the broker's role is limited to facilitating the transaction and not evaluating the financial prudence of the loan. Option C. Focus solely on the property's features and benefits, downplaying the financing concerns as something the client can manage once they own the home. Option D. Thoroughly explain the implications of the higher interest rate, balloon payment, and prepayment penalty to the client, highlighting the potential long-term financial risks and strongly advising them to consult with an independent mortgage broker, financial advisor, and real estate attorney before proceeding. The correct answer is D. Thoroughly explain the implications of the higher interest rate, balloon payment, and prepayment penalty to the client, highlighting the potential long-term financial risks and strongly advising them to consult with an independent mortgage broker, financial advisor, and real estate attorney before proceeding. Explanation. This scenario is professionally challenging because it requires a Colorado real estate broker to balance the client's immediate financial needs with the long-term implications of a financing decision, all while adhering to Colorado's specific real estate financing regulations and ethical duties. The broker must assess the risk profile of the proposed loan without overstepping into providing unlicensed financial advice. The best approach involves thoroughly understanding the client's financial situation and the proposed loan terms to identify potential risks and ensure the client is making an informed decision within the bounds of Colorado real estate law. This includes explaining the implications of different loan features, such as interest rate adjustments, balloon payments, and prepayment penalties, and advising the client to seek independent legal and financial counsel. This aligns with the broker's duty of care and disclosure under Colorado revised statutes, particularly concerning material facts that could affect the value or desirability of the property or the terms of the transaction. The broker's role is to facilitate the transaction and ensure the client understands the risks associated with the financing, not to act as a loan officer or financial advisor. An incorrect approach would be to recommend a specific lender or loan product based on perceived benefits without a comprehensive risk assessment, or advising the client to proceed without independent legal review. This could violate Colorado's regulations regarding unlicensed practice of mortgage brokering if the broker is seen as selecting or recommending specific loan products beyond general market information. It also fails to uphold the fiduciary duty to act in the client's best interest by not ensuring they fully understand the risks. Another incorrect approach is to downplay or ignore potential risks associated with the loan, such as a high loan-to-value ratio or a variable interest rate, simply because the client expresses urgency. This directly contravenes the broker's obligation to disclose all material facts and risks to the client, as mandated by Colorado real estate licensing laws and ethical codes. Failing to highlight these risks could lead to significant financial harm for the client and expose the broker to liability. Finally, an incorrect approach would be to solely focus on securing the loan approval without adequately explaining the long-term financial implications to the client. This neglects the broker's responsibility to ensure the client understands the full scope of the financing agreement, including potential future payment increases or the impact of balloon payments on their financial stability. Professionals should adopt a decision-making process that prioritizes client education and risk mitigation. This involves a thorough needs assessment, clear communication of potential risks and benefits of different financing options, without recommending specific products, emphasizing the importance of independent legal and financial advice, and ensuring all disclosures are made in accordance with Colorado's real estate financing regulations. Question 15. The investigation demonstrates that a licensed real estate broker in Colorado, who is acting as the seller's agent for a property, learns that a prospective buyer who has expressed significant interest in the property is a client of the same brokerage firm, though not directly represented by the investigating broker in this specific transaction. What is the most appropriate and legally compliant course of action for the broker to take? Option A. Immediately disclose to the seller that the interested buyer is a client of the brokerage firm, even though not directly represented by the investigating broker, and explain the implications of this relationship. Option B. Inform the buyer that they cannot pursue the property because they are a client of the same brokerage firm, thereby preventing any further engagement. Option C. Proceed with the transaction as the seller's agent without informing the seller about the buyer's brokerage relationship, as the investigating broker is not directly representing the buyer. Option D. Advise the buyer to terminate their relationship with the brokerage firm to avoid any potential conflict of interest before proceeding with the transaction. The correct answer is A. Immediately disclose to the seller that the interested buyer is a client of the brokerage firm, even though not directly represented by the investigating broker, and explain the implications of this relationship. Explanation. This scenario is professionally challenging because it involves a potential conflict of interest that, if mishandled, could violate Colorado's brokerage laws and ethical standards. The broker must navigate the delicate balance of representing one party, while simultaneously being aware of information that could benefit another party, even if that other party is not directly represented by the broker in this specific transaction. Careful judgment is required to ensure full disclosure and avoid any appearance of impropriety or breach of fiduciary duty. The best professional approach involves the broker recognizing the inherent conflict and proactively addressing it through clear communication and adherence to disclosure requirements. This means acknowledging the buyer's interest in the property and, crucially, disclosing to the seller that the buyer is a client of the brokerage, even if not directly represented by this specific agent in this transaction. This transparency allows the seller to make an informed decision about proceeding with the negotiation, understanding the potential implications of dealing with a buyer whose brokerage has a pre-existing relationship with another client. Colorado law emphasizes the importance of disclosing agency relationships to all parties involved in a transaction to prevent misrepresentation and ensure informed consent. An incorrect approach would be to withhold the information about the buyer's brokerage relationship from the seller. This failure to disclose a material fact about the buyer's representation could be construed as a misrepresentation or a breach of the duty of honesty and fair dealing owed to all parties in a real estate transaction, even if the seller is not a direct client of the brokerage, creates an uneven playing field and prevents the seller from fully understanding the context of the buyer's interest. Another incorrect approach is to proceed with the transaction without any acknowledgement of the buyer's brokerage relationship, assuming that since the agent is not directly representing the buyer, no disclosure is necessary. This overlooks the broader ethical obligations of the brokerage firm as a whole and the potential for perceived or actual conflicts of interest. Colorado regulations require brokers to act honestly and in good faith, and this includes being transparent about relationships that could influence a transaction. Finally, an incorrect approach would be to advise the buyer to terminate their relationship with the brokerage solely to avoid the disclosure. This maneuver is ethically questionable and could be seen as an attempt to circumvent disclosure requirements rather than address the conflict transparently. Professional decision-making in such situations should prioritize ethical conduct, legal compliance, and clear communication over attempts to avoid disclosure through artificial means. Professionals should adopt a decision-making framework that begins with identifying potential conflicts of interest. This is followed by a thorough review of relevant state laws and ethical guidelines, specifically Colorado's brokerage regulations concerning agency disclosure and fiduciary duties. The next step is to communicate openly and honestly with all parties involved, explaining the situation and the broker's obligations. Finally, the professional should document all communications and decisions to ensure accountability and provide a record of compliance. Question 16. Assessment of a seller's needs and market conditions in Colorado. A real estate broker is preparing to present listing agreement options. Which approach best ensures the seller makes an informed decision while protecting the broker's interests and adhering to Colorado real estate law? Option A. Recommend an open listing agreement, highlighting the seller's ability to list with multiple brokers and sell the property themselves without owing a commission, without fully detailing the potential for reduced marketing efforts and increased seller burden. Option B. Propose an exclusive agency agreement, focusing on the seller's ability to avoid a commission if they find the buyer themselves, while downplaying the broker's limited incentive to market the property extensively compared to an exclusive right to sell. Option C. Thoroughly explain the distinctions between exclusive right to sell, exclusive agency, and open listing agreements, detailing the commission structure, marketing responsibilities, and seller obligations for each, and then guide the seller toward the option that best suits their stated goals and risk tolerance. Option D. Present only the exclusive right to sell agreement, emphasizing its benefits for the broker in securing a commission regardless of who procures the buy, and encourage the seller to sign it promptly. The correct answer is C. Thoroughly explain the distinctions between exclusive right to sell, exclusive agency, and open listing agreements, detailing the commission structure, marketing responsibilities, and seller obligations for each, and then guide the seller toward the option that best suits their stated goals and risk tolerance. Explanation. Scenario analysis. This scenario presents a professional challenge for a Colorado real estate broker because it requires them to navigate the nuances of different listing agreement types and their implications for both the broker and the seller. Misunderstanding or misapplying these agreements can lead to commission disputes, legal liabilities, and damage to the broker's reputation. The broker must assess the seller's needs and preferences while ensuring compliance with Colorado real estate law and ethical obligations. Correct approach analysis. The best professional approach involves clearly explaining the fundamental differences between an exclusive right to sell, exclusive agency, and open listing agreement to the seller. This includes detailing how each agreement impacts the seller's obligations, the broker's commission rights, and the level of marketing effort the broker is incentivized to undertake. The broker should then recommend the agreement that best aligns with the seller's stated goals and risk tolerance, ensuring the seller fully understands the implications before signing. This approach prioritizes informed consent and fiduciary duty, which are cornerstones of Colorado real estate practice. Incorrect approaches analysis. Presenting only one type of listing agreement without thoroughly explaining the alternatives fails to uphold the broker's fiduciary duty to act in the seller's best interest. This can lead to the seller unknowingly agreeing to terms that are not optimal for their situation. Recommending an agreement based solely on the broker's potential for earning a commission, without considering the seller's preferences or the market conditions, is unethical and potentially violates Colorado's real estate regulations, regarding fair dealing, suggesting an agreement that is not legally permissible in Colorado for the described scenario would also be a significant regulatory failure. Professional reasoning. Professionals should always begin by understanding the client's objectives and constraints. In real estate, this translates to discussing the seller's desired level of control over the sale, their urgency, and their willingness to pay a commission. Armed with this understanding, the broker can then present the available listing agreement options, clearly articulating the pros and cons of each in the context of the seller's situation and Colorado law. The decision should be a collaborative one, with the seller making an informed choice based on the broker's expert guidance. Question 17. Risk assessment procedures indicate that a licensed real estate broker in Colorado is approaching their license renewal deadline and realizes they have not tracked their continuing education credits diligently throughout the current licensing period. What is the most prudent course of action to ensure compliance with Colorado's licensing requirements? Option A. Immediately consult the Colorado Division of Real Estate's official website and their personal license portal to determine the exact number of continuing education hours required, identify any specific mandatory course topics, and ascertain the remaining credits needed. Then proactively enroll in and complete the necessary approved courses as soon as possible. Option B. Wait for the official renewal notice from the Colorado Division of Real Estate and address any identified continuing education gaps at that point, prioritizing immediate client transactions. Option C. Enroll in any available real estate courses, regardless of their specific content or approval status, to accumulate the maximum number of hours before the deadline. Option D. Assume that the renewal notice from the Colorado Division of Real Estate will clearly outline any deficiencies and provide a grace period for completion. The correct answer is A. Immediately consult the Colorado Division of Real Estate's official website and their personal license portal to determine the exact number of continuing education hours required, identify any specific mandatory course topics, and ascertain the remaining credits needed. Then proactively enroll in and complete the necessary approved courses as soon as possible. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker in Colorado to balance the immediate needs of a client with the strict regulatory requirements for license, renewal, and continuing education. Failure to adhere to these requirements can lead to significant penalties, including license suspension or revocation, and can also damage the broker's reputation and client trust. The broker must exercise careful judgment to ensure compliance while maintaining a high level of service. Correct approach analysis. The best professional practice involves proactively identifying and addressing any potential lapses in continuing education compliance well before the license renewal deadline. This approach ensures that the broker remains in good standing with the Colorado Division of Real Estate, fulfilling all statutory obligations. Specifically, a broker should regularly review their CE transcript, understand the specific course requirements mandated by Colorado law, e.g., the number of hours, specific topics like ethics or agency law, and plan to complete these courses in advance of the renewal period. This proactive stance prevents last-minute rushes, potential course availability issues, and ensures the license is renewed without interruption, thereby maintaining the ability to legally practice real estate in Colorado. Incorrect approaches analysis. One incorrect approach involves assuming that the renewal notice from the Colorado Division of Real Estate will automatically account for any outstanding continuing education requirements. This is a failure to take personal responsibility for compliance. The division's notice is a reminder, not a guarantee of eligibility, and the onus is on the licensee to ensure all requirements are met. Relying solely on the notice could lead to discovering a deficit too late to rectify it before the renewal deadline, resulting in a lapsed license. Another incorrect approach is to believe that completing any real estate-related courses will satisfy the continuing education mandate. Colorado law specifies the types and number of hours of continuing education required for license renewal. Simply taking courses that are not approved or do not meet the specific content requirements, e.g., general sales techniques instead of mandated ethics or agency law courses, will not fulfill the obligation. This oversight can lead to an incomplete renewal application and potential disciplinary action. A further incorrect approach is to delay addressing continuing education until immediately before the license renewal deadline. This creates a high-risk situation where course availability might be limited, unexpected personal or professional emergencies could arise, or the broker might discover they have not met the specific requirements, leaving insufficient time to correct the deficiency. This reactive approach significantly increases the likelihood of non-compliance and the associated penalties. Professional reasoning. Professionals in Colorado must adopt a proactive and diligent approach to license, renewal, and continuing education. This involves understanding the specific requirements outlined in the Colorado Real Estate License Act and the rules and regulations promulgated by the Colorado Division of Real Estate. A robust professional decision-making process includes 1. Regular self-assessment of compliance status, periodically reviewing personal continuing education records and comparing them against current regulatory requirements. 2. Strategic planning for CE completion, identifying required courses and scheduling them well in advance of deadlines, considering course availability and personal schedules. 3. Verification of course accreditation, ensuring that all completed courses are approved by the Colorado Division of Real Estate and meet the specific content mandates. 4. Seeking clarification when necessary, contacting the Colorado Division of Real Estate directly if there is any ambiguity regarding continuing education requirements or renewal procedures. By embedding these practices into their professional routine, brokers can ensure continuous compliance, maintain their license in good standing, and uphold the integrity of their practice. Question 18. Regulatory review indicates that a seller in Colorado has expressed a desire to accept a personal loan from a prospective buyer outside of the standard purchase price and closing process to help the buyer with their down payment. As a licensed Colorado real estate broker representing the seller, what is the most appropriate course of action? Option A. Advise the seller on the potential legal and ethical implications of accepting a personal loan from the buyer. Explain how to structure a legitimate transaction that might accommodate the buyer's financial situation in compliance with Colorado law, and offer to facilitate such a compliant arrangement. Option B. Immediately refuse the seller's request to consider the personal loan and proceed with the sale only if the buyer can secure funds through conventional means, without exploring any alternative solutions. Option C. Agree to facilitate the personal loan between the buyer and seller, ensuring it is documented, but without involving a title company or escrow agent for the loan itself, and without explicitly informing the buyer's lender. Option D. Accept the personal loan on behalf of the seller from the buyer, holding the funds in the broker's personal operating account until closing, and then disperse them as instructed. The correct answer is A. Advise the seller on the potential legal and ethical implications of accepting a personal loan from the buyer. Explain how to structure a legitimate transaction that might accommodate the buyer's financial situation in compliance with Colorado law, and offer to facilitate such a compliant arrangement. Explanation. This scenario is professionally challenging because it requires a broker to balance a client's immediate financial desires with their fiduciary duties and the legal obligations imposed by Colorado real estate law. The broker must act with honesty, integrity, and in the best interest of their client, while also ensuring all transactions are conducted transparently and in compliance with the Colorado Real Estate Commission's rules and regulations. The broker's role extends beyond simply facilitating a sale. It involves providing expert advice and safeguarding the client from potential harm. The best approach involves the broker proactively educating the seller on the implications of their request and advising them on legally compliant alternatives. This means clearly explaining that accepting a personal loan from a potential buyer, outside of the standard purchase transaction, and without full disclosure and proper escrow, could violate Colorado's brokerage duties and the regulations concerning handling of funds. The broker should then offer to facilitate a legitimate transaction that includes the buyer's desire to provide financial assistance, perhaps through a properly structured seller financing agreement, or by ensuring the buyer's lender is aware and approves of any financial arrangements. This approach upholds the broker's fiduciary duty to act in the client's best interest by protecting them from potential legal and financial repercussions, while also adhering to Colorado's strict rules on disclosure and handling of client funds. Accepting the buyer's offer of a personal loan directly, without involving a title company or escrow agent, and without full disclosure to all parties and the lender, is professionally unacceptable. This action bypasses standard legal protections and could be construed as commingling funds or engaging in undisclosed financial arrangements, potentially violating Colorado revised statutes concerning real estate transactions and the handling of earnest money. It also fails to protect the seller from the risks associated with an informal loan agreement and could jeopardize the entire sale if the buyer's lender discovers the arrangement. Another unacceptable approach is to simply refuse the buyer's offer and proceed with the sale as if the offer was never made, without attempting to find a compliant solution. While this avoids direct violation, it fails to adequately represent the seller's interests by not exploring all legitimate avenues to meet their needs and potentially secure the sale. A broker has a duty to advise and assist their client in navigating such requests, not just dismiss them. Finally, agreeing to facilitate the personal loan without understanding its terms or ensuring it is properly documented and disclosed to all relevant parties, including the buyer's lender, is also professionally unsound. This could lead to complications later in the transaction, such as the buyer's lender refusing to fund the loan due to undisclosed financial obligations or conflicts of interest, ultimately harming the seller and potentially exposing the broker to liability. Professionals should employ a decision-making framework that prioritizes client well-being, legal compliance, and ethical conduct. This involves 1. Understanding the client's request and underlying motivation. 2. Identifying potential legal and ethical conflicts with the request. 3. Consulting relevant statutes and regulations, in this case, Colorado Real Estate Commission rules and statutes. 4. Educating the client on the risks and legal implications. 5. Proposing compliant and ethical alternatives that meet the client's needs. 6. Documenting all advice and decisions. Question 19. Consider a scenario where a prospective buyer in Colorado is interested in purchasing a property using an FHA-insured loan. The buyer mentions they have a credit score of approximately 580 and has been saving money from various sources, including some personal loans, for the down payment. As a Colorado real estate broker, what is the most appropriate course of action to ensure the buyer's interests are protected and that the transaction complies with FHA guidelines? Option A. Advise the buyer to proceed with making an offer on the property, contingent only on their belief that they will qualify for an FHA loan and that the lender will sort out the details later. Option B. Advise the buyer that a credit score of 580 is generally acceptable for an FHA loan with a lower down payment. Explain that the lender will verify all down payment sources and recommend they seek pre-approval from an FHA-approved lender to confirm their eligibility and the acceptability of their down payment funds. Option C. Inform the buyer that a credit score of 580 is definitively sufficient for an FHA loan and that any funds saved, regardless of source, can be used for the down payment, as long as they have the amount. Option D. Tell the buyer their credit score of 580 is too low for an FHA loan and suggest they explore conventional loan options instead, without further investigation into FHA specifics or lender pre-approval. The correct answer is B. Advise the buyer that a credit score of 580 is generally acceptable for an FHA loan with a lower down payment. Explain that the lender will verify all down payment sources and recommend they seek pre-approval from an FHA-approved lender to confirm their eligibility and the acceptability of their down payment funds. Explanation. Scenario analysis. This scenario presents a professional challenge for a Colorado real estate broker because it involves navigating the specific eligibility requirements and disclosure obligations associated with government-backed loan programs. Misunderstanding or misrepresenting these requirements can lead to significant legal and ethical repercussions, including potential disciplinary action from the Colorado Real Estate Commission, financial penalties, and damage to the broker's reputation. The broker must exercise careful judgment to ensure the client receives accurate information and that the transaction complies with all applicable federal and state regulations governing FHA loans. Correct approach analysis. The best professional practice involves thoroughly understanding and accurately communicating the FHA's borrower eligibility criteria, specifically focusing on the minimum credit score requirements and the acceptable sources of down payment funds. This approach ensures the client is fully informed about the realistic possibilities of securing an FHA loan based on their financial profile. The broker must then guide the client towards obtaining pre-approval from an FHA-approved lender, who will conduct the definitive assessment of eligibility. This aligns with the broker's fiduciary duty to act in the client's best interest by providing accurate guidance and facilitating a compliant transaction. Colorado real estate brokers are expected to possess knowledge of common loan programs and to refer clients to qualified lenders for definitive loan approval. Incorrect approaches analysis. Advising the client that a credit score of 580 is definitively sufficient for an FHA loan without further lender verification is an oversimplification and potentially misleading. 580 is a common benchmark for a lower down payment under FHA guidelines. It is not an absolute guarantee of approval, as lenders have their own overlays and may consider other factors. This approach risks setting unrealistic expectations, suggesting that any source of funds can be used for the down payment without considering FHA's specific rules on acceptable sources, e.g., prohibiting certain types of unsecured loans or gifts from prohibited sources, is a regulatory failure. FHA has strict guidelines to prevent fraud and ensure borrower capacity, recommending that the client proceed with the purchase contract contingent solely on the buyer's belief they will qualify for an FHA loan, without emphasizing the need for formal lender pre-approval and verification of all FHA requirements, bypasses a critical step in the process. This could lead to the client entering into a contract they cannot fulfill, resulting in lost earnest money and potential legal disputes. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes accurate information dissemination, adherence to regulatory requirements, and client well-being. This involves 1. Understanding the core principles and common requirements of prevalent loan programs like FHA. 2. Recognizing the limitations of a broker's role in loan approval, which rests with the lender. 3. Emphasizing the importance of formal pre-approval from a qualified lender. 4. Clearly communicating eligibility factors and potential challenges to the client. 5. Always referring clients to lenders for definitive financial assessments and loan commitments. Question 20. Upon reviewing a mortgage application for a property in Denver, Colorado, a loan originator finds that the agreed-upon purchase price is $400,000, but the independent appraisal has valued the property at $380,000. If the borrower intends to finance $304,000 of the purchase, what is the correct loan-to-value LTV ratio based on Colorado's regulatory framework for mortgage lending? Option A, 76.00%. Option B, 81.06%. Option C, 80.00%. Option D, 78.00%. The correct answer is C, 80.00%. Explanation. This scenario presents a common challenge for Colorado mortgage loan originators, accurately calculating the loan-to-value LTV ratio when a property appraisal comes in lower than the purchase price. Miscalculating LTV can lead to incorrect loan terms, potentially violating Colorado's lending regulations and ethical obligations to the borrower. It requires a precise understanding of how to apply appraisal values in relation to the loan amount and purchase price. The correct approach involves using the lower of the appraised value or the purchase price to determine the LTV. This is mandated by federal regulations, such as those enforced by the Consumer Financial Protection Bureau, CFPB, and generally adopted by Colorado's Division of Real Estate for mortgage lending. Specifically, lenders are required to base loan terms on the property's fair market value, which is typically represented by the lower of the appraised value or the purchase price, to protect both the borrower and the lender from over-leveraging. This ensures the loan amount is a reasonable percentage of the actual value of the collateral. An incorrect approach would be to use the purchase price exclusively when the appraisal is lower. This fails to account for the actual market value of the property as determined by a professional appraisal, potentially leading to a loan that is too large relative to the collateral's worth. This practice can violate Colorado's consumer protection laws by misrepresenting loan terms and exposing the borrower to undue risk. Another incorrect approach is to use the appraised value without considering the purchase price if the appraisal is higher. While this might seem borrower-friendly in terms of a lower LTV, it can still be problematic if the appraisal is considered inflated or not reflective of true market conditions, and it deviates from the standard practice of using the lesser of the two figures. This can also lead to misrepresentation of loan terms and potential issues with secondary market investors. Finally, An incorrect approach would be to average the appraised value and the purchase price. This method has no regulatory basis and is an arbitrary calculation that does not reflect the actual market value or the agreed-upon purchase price. It would result in an inaccurate LTV, potentially leading to incorrect loan origination and violating lending standards. The professional reasoning framework for a mortgage loan originator in Colorado facing this situation should involve 1. Identifying the core issue, a discrepancy between purchase price and appraised value. 2. Recalling and applying the governing regulatory principle. Use the lesser of the appraised value or purchase price for LTV calculation. 3. Performing the calculation accurately based on this principle. 4. Communicating the implications of this calculation clearly and transparently to the borrower.